What is the average criminal case process here in the state of South Carolina? Hi, I'm Attorney David Aylor, and I'd like to briefly go over a step-by-step process of how the average case works here in the state of South Carolina from a procedural standpoint. First of all, of course, an individual is arrested. Once an individual has been arrested, they will have a bond hearing, usually within 24 hours of the time of the arrest. There'll be a number of different factors that are looked at, but of course the most important for a judge's sake will be whether or not the person is a flight risk and whether or not that person could be considered a danger to the community. Once a bond has been set, an individual can bond themselves out, or they can use a bail bonding company depending on the circumstances. Once they're released on bond, there'll be certain conditions that have been placed on them by the judge who set the bond. If they violate any of these conditions, they can be brought back in front of the judge and their bond can be revoked. When choosing an attorney, there should be a number of things an individual looks at when determining who he or she feels most comfortable with going forward in their case. Within that case, they soon will have a period of time that either themselves or through their attorney, they can ask for their discovery, which essentially is any and all evidence that was used within the arrest and the situation to which has brought them to the criminal charges. If there's videos, they're allowed to have those videos for themselves or through their attorney. If there's reports and writings related to the arrest and the investigation, they're also allowed to have those, as well as any, of course, witness statements made by any other individuals related to the investigation. Soon after that material comes forward, the prosecutor or solicitor, depending on what type of case it is and where it is, will often make an offer. This offer is what is considered to be a plea offer. The offer usually is something less than the initial charge, but not always. That individual then can determine whether or not they want to go forward with the plea offer that's been provided or move forward with a trial. If the case goes to trial, it usually will take several months due to circumstances unrelated to the case specifically and truly due to the structure of the system and particularly the caseload of both prosecutors on a magistrate or municipal level as well as solicitors and assistant solicitors on a general sessions level here in the state of South Carolina. If a person decides that they do not want to go to trial and want to go forward with the plea, it's important that they understand all the terms of the plea and the end results that can, or will come from the actual plea in and of itself. If a person wants to move forward with the trial, it's important that they understand through their attorney that everything involved in the case from an investigation standpoint could be brought against them within the trial in and of itself. If a person chooses to go forward with the trial, the result could be a not guilty verdict. If a person is found not guilty, then they cannot be brought back on that same charge again within the same court. They also could have a hung jury where the jury ultimately cannot make a decision, at which time the judge declares a mistrial. Those charges can and most oftentimes will be brought again by the solicitor's office or the prosecutor's office, but each situation is different. Finally, if a person is found guilty, then the judge then will be responsible for determining what their sentence should be related to the crime that the jury has found them guilty of. Of course, in any situation, if a person chooses not to use a jury, they can always have a non-jury trial where a judge would make the determinations of guilt or innocence. If a person is found guilty, there is an appeal process, but it's important to understand the appeal process in the court that you're in so that you and your attorney can make the best decision on your behalf. These appeals are very time sensitive, and it's important to understand exactly what the terms are with your attorney when determining whether or not you would like to go forward with an appeal of your case. For further questions related to the criminal law process as a whole here in the state of South Carolina, as well as civil procedural and civil issues, you can always contact me at my office, which is 843-577-5530, or on the web at www.davidaylor.com. Thanks for watching.